Right now, a 2024 split screen is playing out, and it's one we're going to see a lot of here in the coming months. On one side, President Biden set to campaign in an absolutely critical swing state, Michigan. Then on the other side, former President Trump in a federal courtroom for a critical hearing in his classified documents case.
Trump is trying to get those charges tossed, but so far the judge has expressed skepticism about some of his lawyers' arguments. The prosecution has also used the former president's own words against him. We have full team coverage with CNN Chief Legal Affairs Correspondent Paula Reed, CNN Senior Justice Correspondent Evan Perez, and at the courthouse, CNN Senior Crime and Justice reporter Caitlin Polantz. Let's start there outside the courthouse. Caitlin, what is the latest out of this hearing?
What's up, people? Welcome to Dr. John Podcast. So this has just happened, guys. A federal judge ordered Trump's own lawyers arrested mid-proceeding. Not sanctioned, not fined, physically taken into custody, after they were caught lying under oath and deliberately concealing documents the court had explicitly ordered produced. The judge called it straight-up obstruction of justice. The legal world is still processing it.
Well, Boris and Brianna, this was a big, bold argument that Donald Trump's lawyers have been making in court, especially this afternoon, trying to tell the judge he had a lot of ability to claim the classified documents at the end of his presidency were personal, and that's the reason he took them to Mar-a-Lago. He should not be prosecuted for a crime. Judge Eileen Cannon already is expressing skepticism at that argument and an argument they made earlier today that the law is too vague around national security records. Just now, just a few moments ago, she told Trump's lawyers it's difficult to see how this gets you to the dismissal of an indictment. She also pointed out that perhaps some of the things that Donald Trump's lawyers are arguing today are the sort of things that you would have as a defense at trial, saying he didn't know he was taking the documents. He didn't willfully want to break the law in this situation. That might be a question for a jury. That's what the judge has been signaling so far.
Let me set the scene for you, because what unfolded inside that courtroom was absolute pandemonium. Multiple witnesses who were present for the hearing have described an atmosphere that shifted from routine procedural matters to explosive confrontation in a matter of minutes. The judge, who had apparently been dealing with months of delay tactics, stonewalling, and what previous orders had already characterized as unacceptable behavior, finally reached a breaking point.
She also has said in court today that perhaps this Presidential Records Act pushback that Trump's team is making, saying that Trump should have so much latitude here to decide the records are his, Judge Cannon seems to be saying that that would allow future presidents to clearly say that a document is theirs when it's clearly the federal government's. That does not seem to be an argument that she's buying. The Justice Department has been making that to her as well, saying that these records that Trump had after the presidency at Mar-a-Lago are so sensitive that it put national security at risk. And they're the type of records that should never have been out of the hands and control of the security of the federal government. Boris and Brianna?
Caitlin, walk us through how prosecutors tried to undercut Trump's argument by actually quoting him.
The fuse had been burning for a long time. Every missed deadline, every incomplete document production, every evasive answer, every promise to comply that turned out to be hollow, it all accumulated until the pressure became unbearable. And when the truth finally emerged, when the lawyers admitted under questioning that they had been playing games with the court, the judge detonated. Legal analysts who have covered federal courts for their entire careers.
They did. Earlier this morning, in the arguments, one of the things that Prosecutor Jay Bratt brought up was what Trump was saying in Bedminster, New Jersey, after he left the presidency to people who didn't have the ability to look at classified documents, when he referred to and held up, waved around a piece of paper that was an apparent military plan from his time in government. Prosecutor Jay Bratt read from that transcript when Trump acknowledges that the record was classified and says to the crowd in front of him he wishes he could have declassified it and shared it more publicly, but he can't. Prosecutor Jay Bratt said in court today that that is the sort of thing that would show you he knew these weren't personal records. He also knew the law. And so these arguments that the Trump team is making today
said they had never witnessed anything comparable. This was the judicial equivalent of a controlled demolition, a moment when the patience of the court expired entirely and consequences became immediate and severe. The underlying facts are almost too incredible to believe, but they're documented in court records and confirmed by multiple first-hand accounts. The hearing was supposed to be about document production, a routine matter really in the context of complex litigation. The court had issued an order requiring Trump's legal team
should not be able to get the case tossed. We're still going to wait to see what else the judge has to say. It's very likely she'll write some lengthy opinion on these motions and other motions Trump has made in court to try and get the case out from this courthouse. But we will see if she says anything more today that indicates which way she's leaning.
All right, we'll be looking for that. We know you'll be following it, Caitlin. And Paula, obviously, Trump's words have played such a key role in so many cases, from E. Jean Carroll, the case there, the Georgia election subversion case with the find the votes call. What about the factor it's going to be in this case?
It's such a big factor. That tape, that audio recording is such a critical piece of evidence. We broke the story that tape existed, and I remember talking to lawyers who were on his team at the time. They only found out that tape existed pretty late in the investigation because of witnesses who had gone into the grand jury
to turn over specific documents. These weren't tangential materials or items of marginal relevance. These were documents that went directly to the heart of the case, materials that both sides knew were crucial to resolving the central disputes. And when Trump's lawyers arrived at the hearing, they took the position that they didn't have the documents. They offered various explanations, some of them quite creative. Attorney-client privilege covered certain materials. Other documents couldn't be located despite diligent searches. Still others were supposedly in the possession of third parties beyond their control.
And I remember them telling me the existence of that tape changed the way they viewed the legal jeopardy that their client was facing. Because remember, at the time, he had all these varying explanations for declassifying, that he had a standing order to declassify things, that he could declassify things with his mind. But this recording undercuts all of that. It also, as the judge has to weigh now, really undercuts these arguments as well. So it is a critical piece of evidence.
And Evan, what are the implications of this argument that Trump deemed these personal matters? When you look at what was actually among these boxes, these are sensitive documents, right?
Right. I mean, we're talking about nuclear secrets. We're talking about the U.S. vulnerabilities to...
If you've followed Trump's legal battles over the years, you'll recognize these as the classic moves in a playbook that has been deployed repeatedly to slow walk proceedings and run out the clock. But this judge wasn't new to the game. This judge had seen variations of these tactics before and had apparently come prepared to cut through the fog. Instead of accepting the explanations at face value and scheduling another hearing for weeks down the road, the judge started asking questions.
A foreign attack, what are the things that the U.S. would do in response to that? And as Paula just pointed out, I mean, that tape makes clear that he knows that these defense programs, these very sensitive defense programs, were still classified, and that he had not actually done some kind of blanket declassification order. And by the way, I mean, the idea of the limit of a president to be able to declassify things, it's not been tested really. And so, until that tape emerged, there was some question as to whether whether he had that power and what is the limit of that power. I think members of Congress and certainly in the Senate have said you can't just declassify nuclear secrets. It's not like that because of the way the government works. So
specific questions, pointed questions, the kind of questions that make it very difficult to maintain a facade if you're not being entirely truthful. And under that sustained judicial interrogation, the carefully constructed narrative began to crumble. One of the lawyers pressed repeatedly about whether certain documents actually existed and whether the team had access to them, let something slip, a crack in the armor. And the judge, sensing the crack...
The implications are huge if this judge sides with him on this.
Can you talk a little bit, Evan, about what the judge is saying here, that the arguments the Trump lawyers are making, that it's premature, this is something, she's leaning against them clearly in what she's saying. And can you explain why and where that leaves Trump?
Well, first of all, what it does is it sort of puts this onto a jury to make that decision. She's saying, look, this is not for me to make that decision. And to be honest, I mean, I'm kind of surprised that we're even having this hearing. She could have had these things briefed, and then she could have made a ruling and said this is something for a jury. But she's having this hearing where the former president doesn't have to even be there. He's choosing to do this. He also could be campaigning in Michigan if he wanted to. But she's giving him this opportunity. Every one of these hearings helps him.
Pushed harder. The questioning became more intense. The atmosphere in the courtroom grew tense. Spectators who had been half paying attention to routine matters suddenly sat up straight because everyone could feel that something significant was happening. Then came the admission that changed everything. The lawyer acknowledged under oath that yes, they did have some of the documents that the court had been asking about. Yes, they had known about them. And yes, the decision not to produce them had been deliberate, a strategic choice.
Delay this whole process. And so I think what she's saying is a jury will have to make that argument, make that decision, and this is an argument for you to present to the jury.
Yeah, she actually said to Trump's attorneys, quote, "It's difficult to see how this gets you to the dismissal of an indictment using the Presidential Records Act
extraordinary
essentially
thing to do, right?
As an argument." What do you make of her seeming to oppose this motion?
I think they knew that, but really the number one priority right now is to delay this case until after this case and the other federal case until after the election, because if he is reelected, he can make both of these federal cases go away. He can have his attorney general dismiss the special counsel and the cases. So really their number one priority right now is delay. So even if she's willing to hear the arguments, they know they're unlikely to prevail on the merits. That for them is a win, because every day, every motion, every filing, that helps them push this back possibly until after the election.
The lawyer actually used language suggesting that the timing of production was being managed for tactical advantage. Think about what that means in the context of a federal court proceeding. A judge issues an order requiring you to produce documents. You have the documents. You know the court wants them, and instead of complying, you make a calculated decision to withhold them because you think doing so benefits your client. That's not zealous representation. That's not creative lawyering. That's defiance of a court order. That's contempt. And when you compound it by initially telling the judge you didn't have the documents, that's not a misunderstanding. That's a lie told to a federal judge, a lie told under oath. The judge's reaction, according to everyone who was there, was volcanic. The transformation in the judicial demeanor was immediate and unmistakable. The professional skepticism that judges maintain throughout most proceedings evaporated and was replaced by something much more visceral. The judge accused the attorneys of not merely bending the truth, not shading their answers, or being economical with the facts, but straight up lying to the court while under oath. Those words, straight up lying, reportedly came directly from the judge's mouth. The robe and the gavel and the formal setting usually sanitize courtroom confrontations, keep them within the bounds of professional decorum. But there was nothing sanitized about this. This was raw judicial fury, directed at lawyers who had apparently been treating the court's authority as something to be manipulated rather than respected. Then the judge went further, much further. The accusation escalated from dishonesty to obstruction. Obstruction of justice. That's a federal criminal statute with serious prison time attached. A judge doesn't use that phrase casually. When a federal judge says on the record that attorneys are participating in obstruction, that's not rhetorical flourish. That's a legal finding with potentially devastating consequences. And having made that finding, the judge decided that the usual remedies, monetary sanctions, stern warnings, referrals to disciplinary committees, were insufficient to address the magnitude of what had occurred. The judge ordered the immediate arrest of members of Trump's legal team. Immediate. Not at the conclusion of the hearing, not pending further proceedings. Right then and there, in the courtroom, with cameras capturing the reaction and court reporters transcribing every word for the permanent record. Now, there is some ambiguity in the subsequent reporting about whether the arrests were actually physically carried out at that exact moment, or whether the orders were stayed pending emergency appeals. Defense attorneys representing other parties in the case might have intervened to request a brief delay. The lawyers facing arrest certainly would have pleaded for time to challenge the ruling, and judges sometimes issue orders from the bench with the understanding that there will be procedural steps before enforcement. But whether the handcuffs clicked on in that exact courtroom or whether the arrests were momentarily deferred, the order itself is extraordinary. The fact that it was issued at all represents a judicial escalation that almost never occurs years in federal litigation. We're talking about a realm of sanctions that most practicing attorneys go their entire careers without ever witnessing, let alone experiencing personally. The chaos that engulfed the courtroom was apparently unlike anything the participants had ever seen. Lawyers who moments earlier had been presenting arguments were suddenly scrambling to avoid being taken into custody. Other members of the legal team were frantically making phone calls, presumably to appellate attorneys who might be able to file emergency motions. Court security personnel, who are always present but usually remain unobtrusive, suddenly became central figures in the unfolding drama. Spectators were stunned. Journalists who had been assigned to cover what was expected to be a routine hearing realized they were witnessing a historic moment and began furiously documenting every detail. The judge, having dropped the hammer, had to restore order to a courtroom that had descended into something approaching bedlam. And here's the context that makes all of this even more significant. This didn't happen in isolation. It's not as though Trump's legal team had been model officers of the court for years and then made one unfortunate mistake that a hot-headed judge overreacted to. The pattern of judicial frustration with Trump's lawyers has been building for months, spanning multiple cases, multiple jurisdictions, multiple judges. Federal judges across the country have been issuing warnings, imposing monetary sanctions, expressing frustration in written opinions about delay tactics and discovery abuses. The patience of the judiciary has been wearing thin, and what happened in this courtroom appears to be the breaking point, the moment when all of that accumulated frustration finally erupted into concrete, severe consequences. Reporting from CBS News in the aftermath of this incident has documented a broader pattern that is genuinely alarming for anyone who cares about the integrity of the legal system. Judges in multiple cases involving Trump and his administration have been making formal findings that testimony provided by government witnesses and legal representatives is simply not credible. Not that they disagreed with the testimony or found it unpersuasive, not that there were gaps or inconsistencies typical of witness recollection, but that the testimony was fundamentally not believable. And in some of the most egregious instances, witnesses and attorneys have actually admitted under oath that they lied about key facts during enforcement proceedings. These aren't allegations made by opposing counsel. These are admissions made by the witnesses themselves when confronted with evidence that their previous statements were false. They admitted lying in open court, with the record running. This pattern has profound implications that extend far beyond any single case. The judicial system functions on a foundation of trust. Judges rely on lawyers to be honest. They rely on witnesses to tell the truth. They rely on parties to comply with court orders. When that trust erodes, when judges start operating from a default assumption of dishonesty, the entire machinery of justice begins to grind and sputter. Cases that should be resolved on their merits become bogged down in credibility disputes. Resources that should be devoted to reaching just outcomes are instead consumed by efforts to determine what's actually true. And the public, watching from the outside, loses faith that courts can fairly adjudicate disputes. If the participants in the system can't be trusted to tell the truth, the system itself becomes a theater of manipulation rather than a forum for justice. The consequences facing these attorneys are genuinely life-altering. Let's start with the most immediate: contempt of court. Federal judges have inherent authority to punish contempt through fines or imprisonment. If these arrest orders are carried out, the lawyers will be physically incarcerated, not in a white-collar minimum security facility where they can play tennis and take cooking classes. Contempt confinement can be in regular detention facilities, and it lasts until the contemner purges the contempt by complying with the court's order. For these attorneys, that means producing the documents they were supposed to produce, providing truthful testimony about what happened, and demonstrating to the court's satisfaction that the obstruction has ended. If they maintain their defiance, they can sit in jail indefinitely. The Supreme Court has long recognized that courts possess this power precisely because without it, judicial orders would be mere suggestions that could be ignored with impunity. Beyond contempt, there's the very real threat of disbarment proceedings. Every state bar association in the country has rules of professional conduct that govern attorney behavior. Lying to a court is among the most serious violations imaginable. It strikes at the core of what it means to be an officer of the court. State disciplinary authorities take judicial findings of dishonesty extremely seriously. When a federal judge makes an on-the-record determination that lawyers lied under oath, the bar associations will almost certainly open investigations. And if those investigations confirm what the judge found, the penalty can be permanent disbarment. The loss of a law license isn't just a temporary setback. For attorneys who have spent decades building careers, who have families depending on their income, who have professional identities wrapped up in their ability to practice law, disbarment is a professional death sentence. They can never practice again. The investment in law school, the years of building client relationships, the reputation painstakingly constructed over a career, all of it evaporates. Then there's criminal exposure. Obstruction of justice is a federal felony. Perjury is a federal felony. Making false statements to federal officials is a federal felony. The statutory maximums for these offenses are measured in years, sometimes decades, of imprisonment. Federal prosecutors have broad discretion to bring charges when evidence of criminal conduct surfaces during court proceedings. And the evidence here isn't subtle. It's a transcript of a hearing where a judge found that lawyers lied and obstructed. That's about as clean a referral for prosecution as you could imagine. The Department of Justice wouldn't need to conduct a lengthy investigation or piece together circumstantial evidence. They would just need to read the transcript and determine whether to present it to a grand jury. For Trump himself, the implications are grave and multi-layered. His entire legal defense strategy across multiple cases has been built on a foundation of aggressive delay. File motions, appeal rulings, contest every procedural step, push deadlines, overwhelm the opposition with paperwork, run out the clock, and hope that political developments or changes in the legal landscape make the cases go away. That strategy, whatever its ethical merits, has achieved some tactical successes. Trials have been delayed, proceedings have been postponed, the calendar has been stretched, but that strategy depends entirely on maintaining at least a baseline of credibility with the courts. Judges have to believe that when your lawyers make representations, those representations are truthful. They have to believe that document productions, even if slow, are being conducted in good faith. They have to believe that the delays, even if frustrating, are the product of legitimate legal disputes rather than deliberate obstruction. What this incident demonstrates is that the credibility account has been completely drained. The judges aren't just skeptical anymore, they're openly contemptuous. They're making findings of dishonesty. They're ordering arrests. Every future filing by Trump's legal team will be received against this backdrop. Every request for an extension will be scrutinized for bad faith. Every representation about what documents exist and where they are will be met with suspicion. The benefit of the doubt that even controversial litigants usually receive has been burned to ashes, and that makes mounting an effective defense extraordinarily difficult because the legal system, for all its procedural complexity, ultimately runs on trust. When the court doesn't trust you, everything becomes harder. The practical problems multiply quickly. If these lawyers are actually incarcerated, they can't represent Trump. In jail, their access to legal research tools, their ability to communicate with co-counsel, their capacity to prepare for hearings and draft filings, all of it is severely constrained. Trump would need to find replacement counsel. And finding competent lawyers willing to represent him was already challenging before this incident. Trump has a well-documented history of not paying legal bills, of ignoring legal advice, of making public statements that undermine his own defense. Many top-tier law firms have decided that the reputational costs of representing him outweigh any financial or professional benefits. Now, with the added risk that representing Trump could get you arrested, the pool of willing attorneys shrinks even further. Who signs up for a client when the previous lawyers were ordered taken into custody? Who risks their license, their freedom, their career? The political dimension of this is equally dramatic. Trump has spent years cultivating a narrative of victimhood, telling his supporters that the legal system is corrupt, that judges are biased against him, that the deep state is engineering prosecutions to bring him down. This narrative has been remarkably effective at maintaining the loyalty of his base. True believers accept it as an article of faith, but this incident strains reins that narrative to the breaking point because it's not about partisan prosecutors bringing questionable charges. It's about federal judges, many of them appointed by Republican presidents, enforcing basic standards of honesty and compliance. It's about lawyers getting caught doing something that pretty much everyone agrees is wrong, lying to a judge. Even people who believe the system is rigged against Trump might pause when they hear that his lawyers admitted to hiding evidence and were ordered arrested as a result. That's not a witch hunt. That's the system saying you broke the rules and now there are consequences. The media amplification of this story is unavoidable and devastating. The visual of lawyers being ordered arrested in federal court is inherently dramatic. It's the kind of story that breaks through the noise of a crowded information environment. Cable news will run the footage, if it exists, on endless loops. YouTube legal commentators will dissect every nuance of the judge's ruling. Newspaper headlines will capture the shock of the moment. Social media will spread clips and quotes and reactions at viral speed. Everyone who pays even minimal attention to current events will hear about the time Trump's lawyers got ordered arrested for lying in court. That shapes public perception in ways that carefully crafted press releases and campaign speeches can't counteract. You can spin policy disagreements. You can spin procedural rulings. It's much harder to spin your own lawyers getting taken into custody for misconduct. Independent voters, the ones who don't follow every twist and turn of the legal saga but tune in when something truly dramatic happens, are particularly important here. These are people who might have been willing to give Trump the benefit of the doubt, who might have accepted the argument that the legal cases were politically motivated. But when they see federal judges ordering arrests because lawyers lied and hid evidence, that narrative becomes harder to sustain. The story shifts from partisan dispute to something more fundamental: basic honesty and respect for the rule of law. And that's terrain where Trump's political defenses are weakest. Looking slightly further ahead, this incident will reverberate through the political landscape for months and years. The midterm elections are approaching, and Democratic candidates now have a gift-wrapped issue to campaign on. They can point to courtroom transcripts and judicial findings and ask voters whether they want a political movement that treats courts as obstacles to be manipulated rather than institutions to be respected. They can argue, with documentary evidence to back it up, that Trump's orbit is so ethically compromised that even lawyers are getting arrested. That's a powerful message, made more powerful by the fact that it's grounded in official court proceedings rather than campaign rhetoric. The presidential election cycle beyond that will also be shaped by these events. Trump's influence over the Republican Party remains substantial, but each legal setback makes his endorsement a more complicated proposition. Candidates who seek his support will have to answer questions about whether they condone the conduct that led to lawyer arrests. They'll be asked in debates and interviews whether they believe the judge was wrong to sanction dishonesty in court. They'll have to navigate between a base that remains fiercely loyal to Trump and a broader electorate that views the legal chaos with mounting alarm. That's a tightrope that not every politician can walk. There's also a deeper question about what this means for the rule of law in America. We're watching, in real time, the judicial system attempt to enforce its norms against powerful actors who are determined to resist. This is a stress test of institutional integrity. Can courts actually compel compliance when the parties before them have political power, media platforms, and millions of supporters? Or will the enforcement mechanisms prove inadequate when the targets are wealthy, connected, and determined to fight? The arrest orders represent the judiciary reaching for its most potent weapon. If that weapon proves effective, if the lawyers face real consequences, it reinforces the principle that nobody is above the law. If the orders are appealed endlessly, reversed on technical grounds, or otherwise neutralized, it sends the opposite message, that the system lacks the teeth to enforce its own rules against those with resources to resist. The international community is watching this unfold with a mixture of fascination and concern. America has long positioned itself as a model of democratic governance and rule of law. Our diplomats lecture other nations about judicial independence and anti-corruption measures. Our foreign policy is premised on the idea that democratic institutions deserve emulation and support. When a former and potentially future president's lawyers are being ordered arrested for lying in federal court, that complicates the message enormously. enormously. Allies wonder about American stability. Adversaries see opportunities to exploit perceived dysfunction. The global perception of American democracy is being shaped by these courtroom dramas in ways that will outlast any individual case or election cycle. The question of what happens next is consuming the legal community. If the arrest orders are carried out, the lawyers will be in custody. Trump's defense operations will be severely disrupted. If the orders are stayed pending appeal, there will be a frantic effort to get appellate courts to intervene. The lawyers will argue that the judge abused discretion, that the conduct didn't warrant such extreme measures, that lesser sanctions should have been imposed first. The government, or whichever party is on the other side of the case, will argue that the judge's findings were well supported and that appellate courts should defer to the judge who actually witnessed the misconduct. This fight could work its way through multiple levels of appellate review, consuming months and generating more headlines at each stage. Disbarment proceedings will commence regardless. State bar associations don't wait for contempt appeals to conclude before opening investigations. They'll request transcripts, review the judge's findings, and begin the process of determining whether the lawyers violated professional conduct rules. Those proceedings will create additional legal jeopardy, additional legal bills, additional public scrutiny. Even if the lawyers somehow avoid jail time, they may face the destruction of their professional careers through administrative processes that have lower burdens of proof than criminal cases. Criminal investigations are also a distinct possibility. Federal prosecutors read the news. They follow high-profile court proceedings. When a federal judge makes findings that suggest criminal conduct occurred, prosecutors take notice. They may already be reviewing the transcripts, assessing whether the evidence supports charges, determining whether to open formal investigations. The existence of a detailed factual record created in open court makes their job substantially easier. The evidence is already gathered, transcribed, and sworn. The findings have already been made by an Article 3 judge. The referral for prosecution, whether formal or informal, is practically written in the judge's own words. For observers trying to understand what this all means, the big picture is this. We have entered a new phase of the Trump legal saga. The era of delay and evasion is colliding with the judiciary's institutional limits. Judges who might once have tolerated aggressive tactics are no longer willing to do so. The consequences for misconduct, which previously existed only as theoretical possibilities, are becoming concrete and severe. Lawyers are facing arrest, disbarment, and potential criminal prosecution. The client they were defending is facing a legal landscape where his standard strategies no longer work, and where the courts are increasingly treating his entire operation as fundamentally untrustworthy. This is an escalation that changes the trajectory of every case, every investigation, every proceeding. The fuse that has been burning for years has reached the dynamite. And what blew up in that courtroom will reshape the legal and political landscape for a long time to come.